Hey everybody, welcome. It's September 6th. We're here with Kevin A. Gregg on episode number 260, doing our regular session about immigration court and BIA and all that kind of stuff that Kevin is the expert in. You missed one last month. We're going to make up for it this time. So I'm really happy to have him on the show. To start, I want to obviously thank the guests, but also want to thank everyone, the viewers, for listening. We've already got a lot of RSVPs for people that want to come to the conference, workshop, postgraduate session we're going to have in Los Angeles, focusing on employment-based category. Right now, it seems like we're going to focus on O's to give you A to Z of it, cover letter breakdown, all this kind of stuff. We're getting together, maybe add additional visa category. But what I would want you to do is just go on the website, immigrationlawyerstoolbox.com/conference, and RSVP. We have some information there on prices, but that's probably all going to change. So just get your name out there so we can make sure to remind you and send you a breakdown of the agenda and everything. Our goal is to have it where not only is there like you learn a visa category that you can run your business on, but also it's gonna be heavy one-on-one experience and mentorship and grouping, so that you have friends you make there, network you make there, and afterwards that continues. Because that's an important part of immigration practice is connecting with other immigration attorneys and having long, deep relationships. That's the only way to really practice well. So we're going to try to work on developing that with you in LA and have a good time too. Go to some good restaurants and have some good food and all that kind of stuff. So just RSVP there. Check out the magazine, the Immigration Lawyer Toolbox magazine. The next issue is coming out in a couple of weeks, but issue 5 is there. It's going to be it is a great one. I really want you to check it out and learn all about a lot of different categories that'll help you in your practice. Go to immigrationlawyerstoolbox.com/magazine and check out the sponsors we have there. Argo is a great sponsor we have. They do a lot of great work with immigration lawyers. And also DocuWise, obviously, who's a great sponsor for the magazine, the podcast. They do a lot of great work helping, run your practice and manage your practice. Having said that, I have a course on marriage-based green cards. You can always check that out, learn more. Email me at info@immigrationlawyerstoolbox.com. Let's jump into it. Kevin, how are you doing?
Not as good as you, man. No rest for the wicked. Do you ever stop?
Well, no, and I also just have a 2-week-old baby right now too. So we're going on 4 hours sleep a night or less.
Good
But
Lord.
it's just so much fun stuff to do in life. The older I get, the more energy I get. It's a wonderful thing when you find out what you want to do in life, and then you take care of yourself, exercise, and eat better, all this kind of stuff, and you're making money, and all this stuff comes together. And like, yeah, life is pretty fun. Like, a kid was so annoying. You have no agency when you're a kid. At least I didn't. Where I was, for most people, it's like this. We're waiting for life to happen, and for parents or other people, older people, to do it. And now I see like there's young people who are really successful. They took charge of life at a young age and just made things happen. I wasn't until I was like mid-20s. I'm like, wait, I could, control my life. I don't have to go to school and then graduate and then go to a law firm or something like that. I could take control of my life. When that happened, and now after 15 years of control of my life, it's like, all right, I see I created what I want and I want to create more of it. So it's really exciting.
Rock and roll. Definitely agree with you there on the frustrations of childhood not having any agency. You put that pretty well. Yeah, it's cool. It's cool, man. Congrats with all that. I'm doing great. My wife and I just moved, and doing the conferences, doing the cases, doing the removal hearings, federal court, doing all the things nonstop, and it's fun. It's fun. I love doing the podcast. I love the cases. And last week, one of the partners at KKTP, Ed Ramos, he pitched in for a case, and it's fun stuff. It's cool. I'm doing like one thing in addition, like a little entrepreneurial on top of the immigration practice. You're doing like what, 3? You got the podcast, you've got a magazine, you've got a conference. So it's fun times 3, 4.
Well, when I have friends like you come and help on the podcast, and you're having an article in the next issue, it makes my life much easier.
I gotta write that. I gotta write that article. I will write that article. I know what I'm gonna write. I got the cases, and I know what I'm gonna do. I gotta sit down and do it.
What you is hard because I intentionally minimize my office, so I was focused on I was doing business and then marriage, and I brought it down to marriage. Now I'm expanding back to business now that I have people. But you're traveling a lot, and that's a toll on you. How do you handle going to different courts and stuff like that across the country?
I actually think it's fun. The only thing that's bad about it to me, don't like being separated from my wife, but like in addition to that, like the other cases back up. Like I'm very much of the opinion that like when it's time to go to your interview or your individual hearing or something like that as a client, like you get 100% of my attention because the game is on. And that by definition backs up some stuff. And so it's a bit of catch up every time, but it all works out. And cell phones make emailing so easily when you're not, committed to when you're waiting or right afterwards. But it is cool to see these cities and, have dinner in other places and having friends in other places. I'm going to go see my great uncle in San Francisco. Just booked that one today. I'll be in San Francisco next month. So it's all good.
Very good. So what's going on? What has happened? I mean, we have kind of a backlog, but I guess the cream of the crop of the case the last 1 or 2 months. How's it look?
That's right. No, because it's backlog from 2 months. We're going to do 35 cases right now. So strap in. Dude, I don't know what's going on. I got 4 cases. And of course, I saved the good ones only for your show and try and stick to the 9th. Do some USCIS when they exist because I know you like that. But actually, there's none this time. But I don't know what's happening. This is now the third. The podcast. My podcast has been around for 2.5 years, but it's gone through 3 July, August times because I started in May 2020. Mm-hmm. And I don't know what happens. The circuits just go nuts in August. This is now the 3rd year in a row, like multiple 9-case weeks. I don't know. Something happens in the circuits in August. So there was certainly a lot going on in the last 2 months, which let me tell you something, like moving houses on a 9-month week and doing that in addition to everything else, man, that'll put you through. But I got the good ones for you. Some of the good ones. I got 4. And so I'll start out with the BIA. And, the listeners probably know some of these. Matter of Fernandes. It's the big one that came out of the BIA in the last 2 months. Again, deficient NTAs. If you're getting sick of them, because I come on your show and talk about them so much, God knows what I am. This is probably the 100th deficient NTA case. But it's going to just keep going on because if an NTA that doesn't have the date, time, and location of the first hearing implicates so many parts of the INA. And you're just going to have these circuits in the BIA addressing all these issues. Some of them, they'll overlap one another. They'll have a conflict. I'm sure something is going to go to the Supreme Court. Quite frankly, whether or not an in absentia removal order needs to be reopened when it was begun with a deficient NTA, I believe will probably go to the Supreme Court within the next 2 months. There's now a circuit split on that issue, with the BIA and the 11th Circuit on one, even though the BIA is not a circuit, and the 9th Circuit and the 5th on the other, but the 5th's all over the place, and that's just 4 entities. So, but putting that aside, that's not what Matter of Fernandes is. That is the Matter of Fernandes, the BIA finally coming around to what needs to happen when there's a deficient NTA in the removal proceedings. The BIA got its hands slapped because it addressed this issue with Bermuda's Coda 2 years ago that said it doesn't matter, a notice of hearing fixes it. Niz Chavez says, no, it doesn't. And finally, in Matter of Fernandes, BIA comes back, says, you know what? You gotta dismiss the case.
Yeah.
Immigration judge. Now that's a paraphrasing of it, but in fact, I'll get to in a sec. They don't say you have to dismiss, but they're saying if it is timely raised, and to me, Matter of Fernandes means if the attorney or the non-citizen says, hey, judge, my NTA is deficient, before the removal proceeding ends, before there's a final order. If that happens, it seems like the BIA is saying the immigration judge can't ignore it. And the BIA quite clearly says the non-citizen need not show prejudice. They need not show anything bad happened to them because of the deficient NTA. And that's a big holding because some circuits had held that you do need to show prejudice, but it's going to be hard to show prejudice. I mean, if they show up to their next hearing, where's the prejudice? You can make arguments. I've been making the arguments, and they're not frivolous, but I think it's hard. BIA says no prejudice showing is required at all if it's timely asserted, and again, timely assertion seems to be before the end of removal proceedings. Now, the 7th Circuit goes farther and says never need to show prejudice if timely asserted, but if it's untimely, then you could still win if you show prejudice. The BIA, in contrast, seems to be saying if it's not timely, you get nothing. And we'll litigate that. We'll see what happens.
Like, are there probably like a million cases that this hits, or how like?
Well, it's only with the Matter of Fernandes, at least. This is only the active cases in immigration court. How many active cases? Let's call it 1.5 million. How many of them were begun with a deficient NTA? I don't know. Pereira was published by the Supreme Court in 2018. So, hopefully they've gotten their act together a bit. I've still seen deficient NTAs after Pereira, don't get me wrong. But, we're talking hundreds of thousands. Now, the BIA says in Fernandes that the immigration judge doesn't have to dismiss. The immigration judge could, as a matter of discretion, give DHS an opportunity to fix the deficient NTA. But as Judge, what's his name? Is Judge Grant in dissent? So it was a split decision from the BIA. Yeah, as Judge Grant says in dissent, that's not possible because there can only ever be one NTA in a case at any given time. So the second DHS must by definition withdraw the first NTA and then issue another one. But the second an NTA is withdrawn, proceedings are terminated. So like, and it's all termination without prejudice. So even if the case is dismissed or terminated, all DHS has to do is turn around and serve a new NTA, a compliant one. But they don't always do that. And who knows? And there's just so many implications in all of this. And so matter of Fernandes is the board in large part finally coming around to, hey, the Supreme Court, based on the statutory text, created a serious issue in Pereira and Chavez. We got to listen, Supreme Court.
It's just like, this is an ongoing issue. It seems like it's never going to end. Affects so many people. And it's just like the Justice Department kind of has to get its act together with DHS and draw a line and say, okay, some of these people, okay, you're lucky. Would you do it? Just kind of clean house, because it seems like it's eating up a lot of resources. There are probably a lot of people filing lawsuits and BIA appeals, clogging that system over this. Like,
our
solution is, clear the system with this.
To be honest with you, to me, this is the obvious thing that the board had to say. I think the interesting one is the in absentia motion to reopen, which I think I've even talked on your show a bit about that. There's a split decision. If, like the Ninth Circuit said in Singh, and what the Fifth Circuit kind of said in Rodriguez, but they've now walked it back a bit. If it is the case, based on the statutory text, that an in absentia removal order must be reopened if premised on a deficient NTA. I mean, you're talking about 3 million cases since 1997. I mean, I have no idea and so many of them have been in this country even after the in absentia removal order. They've married a U.S. citizen. I mean, that would give a path to a green card to tens, if not hundreds of thousands of individuals based on the statutory text, because DOJ and then later DHS was not complying with the statute. And that, I mean, I think the Supreme Court will have to step in there. You've already got a circuit split. So it's fascinating stuff. But I think matter of Fernandes was the natural result of Chavez. But we'll see what happens.
Such a mess. It's just like so weird that this system works the way it does. I mean, I deal with USCIS and NBC and all that kind of stuff, but it's like, this is court. This is like big boy stuff. We're getting deported. Like, how could you?
Yeah.
As kids, we all grow up hearing the Miranda rights, saying you have the right to remain silent, this and that, and we all think it's just like a movie thing. It's a constitutional thing that police have to inform people of their rights. And growing up, I was like, well, like, how do lawyers win sometimes? Because like, why doesn't every cop just say it? Isn't part of the thing? Or like when they're doing searches, don't they do proper search procedures, get a warrant? It seems like a given thing. But like police and prosecutors all the time, they make errors. They don't go by the book. They're kind of lazy or they forget stuff. And they mess it up, and it's just like really like, you're professional. Come on, like just do the basics, write the date or something like that. It's like,
I will say, if I was a DHS trial attorney, I'd be pretty frustrated by this, because under the regulations, a DHS trial attorney is pretty much the only DHS officer who does not have the authority to serve an NTA. So you would think that, like, hey, just like trial attorney, you've got a deficient NTA, fix it. Let's just go, right? But they can't do it. I have no idea what the process is, but I'm sure they have to get some sort of officer to issue a new NTA. They have to be the one organizing it, connecting this person with this person, and making sure it's filed. It must be an administrative nightmare for a DHS trial attorney. I have no idea, but I know that they have to get someone's assistance. They can't just do it themselves. So, I mean, that's the reg. That's the reg that they wrote. So there they are. That's your feel bad for DHS trial attorney comment for the week. And I'll try to go through the other ones quicker. Sorto-Guzman v. Garland out of the Fourth Circuit. First of all, I must discuss it because the attorney is Jeremy McKinney, who is the AILA president. So he gets his props on my show and now yours because he's AILA national president, but also because this case is just awesome. The Fourth Circuit is the tip of the spear on asylum case law. And you'll find the best precedent on almost all aspects of asylum. And
where is the Fourth Circuit?
Fourth Circuit's Maryland, Virginia, and I'm not sure who else.
East Coast over there. Okay.
East Coast, yeah. And it's not just the judges who are appointed by Democrats. Judge Quattlebaum is a Trump appointee, and he's got some of the most impactful decisions since I started the podcast 2.5 years ago. Sorto-Guzman is good for two reasons. First of all, it's the Fourth Circuit reiterating strongly that just a death threat without anything else is past persecution. Like, this is all over the circuits, and some circuits want to say you got to show harm, but no. And past persecution is so important because once it shows, the burden shifts to the government. There's a presumption of a well-founded fear if you show past persecution. And so the judge who doesn't want to grant will be arguing that you haven't shown it. But the Fourth Circuit, they say it twice in a row on purpose, and they italicize it in this case. The threat of death alone is past persecution without anything more. Now, there's a there's a little more. No requirement for harm. I mean, it must be. Can't just be flippant, right? Like, not some guy walking down the street saying I'm gonna kill you and they're mentally ill, that kind of thing. But a death threat alone. This is also important.
Actually, how do you prove that? Is it just hearsay kind of thing? Like, this person said it? It's not gonna right.
Like hearsay is admissible in immigration court. Sorry about my face, by the way. They got a light in my room, and the sunlight keeps changing, and I'll try and stay back. But how do you prove it? Hearsay, they testify, but you get sworn statements from friends or family who are in country who know about it. And, with all the technology, when I'm putting these cases together, though, I mean, there's often a wealth of evidence in WhatsApp messages, on Facebook. And the other side sometimes is using that as well. I mean, be careful. Sometimes people will say, like, there was a case a couple months ago where the guy is like, I was in hiding in this country in Africa for 6 months. I couldn't do anything. And then they showed that he had been posting on Facebook during that time. He's like, you said you didn't have electricity. How were you posting on Facebook? And he's like, So be careful, check social media. But you can use that to your advantage, too, to get evidence. And that's why credibility comes into play in these cases, because hearsay is admissible. And so once the immigration judge says, I believe you, it becomes much harder to deny a case. Sorto-Guzman is also very important because she was harmed outside of a church, and gangs ripped off her cross and said something bad about Christians, Catholicism. And then, like, a couple more times, she was abused. She was beaten pretty savagely, and she was extorted in manners that I think everybody agree is probably not persecution, because it was not because of a protected ground. But the religion one was. Mm-hmm. And so the Fourth Circuit is saying, look, you have one. All you need is one, judge. Yeah. That's past persecution. They ripped her chain. They threatened to kill her. That's past persecution. And those other things, that by the same gangs, that just goes to show that they are willing to follow through. It doesn't matter that it wasn't on account of a protected ground later. So I thought that was an important thing, because nexus to a protected ground is always a way that these cases are getting lost. All you need is one. Fourth Circuit reminding us.
Interesting. Thank you.
Cool. Ballinas-Lucero v. Garland. I'll do 2 Ninth Circuit ones and then be done, because you and I are both sweating desperately in the Ninth Circuit in Southern California during this heat wave. If I wasn't from South Florida, I don't know what I'd be doing. But to be honest with you, this is kind of child's play, actually. You don't know heat until you're dealing with power being out for 4 days following a hurricane in the middle of August.
Oh, it is humid over there too.
It is. Yeah. No, it's quite hot. And we're getting through it.
The problem is, like, every day. Like, it's been 2 months where it's 100 every day. I grew up here. I never had this consistent amount of heat with no cool off. We were going to go to Disneyland yesterday. We canceled. I'm like, I'm not going to Anaheim tomorrow and burn my head off over there. So
it scares me, right? I mean, it's global warming. It's climate change, and I don't know if there's any going back.
Yeah, it's kind of scarier than COVID, because I'm like, COVID, it's a disease, we'll get over it. But like if it's hot every day like this, like, we can't live. Like, I don't need to go out for work because we just do here, but there's people I gotta do work outside the house, and power line goes out, sometimes go there, or laborers and stuff. Like, how are these people going to do any work outside the house? So it's a messed up situation, plus the water. But that's a side issue. Sorry, go ahead.
That's right. Let's make a deal. If either of us runs out of water, we'll help the other one out. You heard it here first on the podcast. I'll get quick with Ballinas-Lucero v. Garland. It's about vacated convictions. It's interesting because the guy, if we're taking him at what he testified to, he's like been this good guy, this father of two people here unlawfully, working at a manager at a Burger King for all these years, hard work, and he gives the wrong change, makes a mistaken change, which it can't be more than a couple dollars, to a mentally ill individual, and the mentally ill individual's caregiver accused him of like trying to scam a mentally ill individual, and everything else in his life, at least based on this decision, showed that must have been a mistake. And who knows, just going based on what they said in this decision, what it seems on the testimony. But the guy accepts a plea by himself, not understanding English, in state court. And like he's in deep because now that prevents him from getting relief. But on the appeal, he gets it vacated, and this is all about reopening his case. And the BIA denied reopening, but this case is very important because he gets it vacated under California Penal Code Section 1018. I'm not a criminal defense attorney. I know some people are, or they definitely use criminal defense attorneys. And what I'm about to say is a bit broad. There's a bit of context in this case, as they always are. But it seems that this is the Ninth Circuit saying that a vacated conviction under California Penal Code Section 1018 will satisfy the immigration standard in matter of Thomas and Thompson, matter of Pickering, and that conviction, that vacated conviction, is no longer a conviction for immigration purposes. And if that's what the Ninth Circuit is saying, and I think that is a reasonable interpretation of this case, Ballinas-Lucero v. Garland, that's huge, because it seems like Cal Penal Code 1018 is a common way to get convictions vacated. Again, that's not what I do. I farm it out. But that's a big holding. And, like I said on the podcast when I summarized this case a few weeks ago, criminal counsel needs to be careful in their memos to the state court, because those are going to get admitted into immigration court. And if criminal counsel saying we need to get this vacated for immigration purposes, maybe immigration judge is going to look at that and say, I don't care what the Ninth Circuit said. I'm reading that decision narrowly. It's clear here that it was for immigration purposes. So I'm not going to recognize this vacated the fact that it was vacated. I think that's possible. And then you're litigating that issue before the BIA. Mm-hmm. So make sure that, but also it seems that you can't, that's the whole basis for the Ninth Circuit saying that a Cal Penal Code Section 1018 vacation will work. The whole basis is that statute in California is substantive. It shows that there was something wrong with the underlying conviction. And quite frankly, then, if that's what they're saying as a matter of law, it doesn't matter what you write in your legal brief. Yeah. That's just bad attorneying. But as a matter of law, all you needed to prove was there was a substantive error. Cal Penal Code 1018, check it out. Tell your criminal counsel, as I said on LinkedIn and on the podcast.
Get the word out with this.
And send your colleagues matter of Thomas and Thompson and matter of Pickering, because they need to know that when they're getting a conviction vacated. Because if they don't, what they're doing is just a waste of client money. Because Attorney General Barr really limited the circumstances whereby immigration judges are permitted to recognize the effect of a vacated conviction.
I haven't read this case this first time. I don't know all the facts, but it sounds like just something so insignificant. This person's life went topsy-turvy. Probably crazy. 10 years probably of litigation to get to this point, probably, and thousands of dollars. Whole life is like hanging by a thread. Like
it's crazy.
Yeah. At a consultation today, and everyone happens once in a while, is a young guy who came as a baby, left as a baby, then came back in, but there's going to be subject to the permanent bar, and there's no age thing for the permanent bar, so he's stuck with it. So now, I had to tell him that. I was just like, I feel like telling somebody you have like some disease or something like that. I want to name somebody, but it's just like, sorry, you're permanent bar, so you got to leave for 10 years, and it's like that's so disruptive of your life and stuff. It's a mess. And this kind of stuff, you go through this.
It's crazy. I know IIRIRA and Immigrants List, they are advocating for statute of limitation type things on all of the inadmissibility provisions.
Yeah.
And maybe the removability ones too. I mean, 212A9 is what they've got their sights set on, but I don't know if they've got the votes. Who knows?
Well,
vote no.
we should mention, I got an email saying Immigrants List is doing their first conference as well. You got to plug these things, you work with IRA.
I don't work for Immigrants List. I didn't even know about their conference until just now. And I know what they're doing a lot, but I was not aware of Immigrants List
I got an
conference.
email saying Immigrants List is doing its first conference, something like that. IRA essentially has IRA's like thing, or I mean, he's part of it generally.
There's a whole team, and it was he birthed it with other people, and he's very involved in it. But I mean, at this point, they've got lobbyists, individuals in DC who do this as their living, like any other political action committee. And it's also Sui Chung is on the board, and Michelle Canero, I believe, and a variety of other individuals. It's definitely a group project, but of course, IRA and our firm are very involved in Immigrants List. I support them. It's the only real political action committee advocating for immigration reform that's fair for non-citizens. And you've got, to use a bad word, you've got fair on the other side lobbying strongly for these policies that would really harm non-citizens. You think it's bad now. If fair had their way, you would have a really draconian immigration framework. And so I'm very pro Immigrants List. I mean, IRA's been around forever. He knows this stuff better than anyone. And he came to the conclusion in the early 2000s that, quite frankly, we're all just arguing around the margins until there is significant reform to reel back IIRIRA from 97. That is how you really do this. Everything else is games and helping people at the margins. And so if IRA came to that conclusion,
he's right. I mean, for those who are familiar, IIRIRA is the 1996 rule that President Clinton signed in, and it created a 3 to 10-year bar, the permanent bar. It's just
really, a lot of other things.
Amongst other things, yeah. They got to ease up on that stuff. The waiver, 601 waiver, the whole system. I despise waivers because I think it's such a stupid system they create that I don't want to do them. But it's like you got to do them, and so but it's just like extreme harsh standards, such a mess.
I mean, that's the thing. I mean, Ballinas-Lucero, and I don't know if the 101A, I do know 101A48, the definition of a conviction under immigration law, is amended with IIRIRA to, in part, change a non-citizen favorable BIA decision, matter of Ozark. So that's an IIRIRA thing. This whole thing, Ballinas-Lucero, and the immigration judge is correct. And this could change with immigration reform. The immigration judge essentially says, sir, I understand. I believe you. There's nothing I can do. I'm not allowed to look behind your criminal conviction, even if I believe that this was all a mistake. The immigration judge is right. They're not. Cancellation of removal, which is what he was applying for, non-LPR cancellation of removal, that used to be suspension. Yeah. And this high standard that I always talk about on the podcast, exceptional, extremely unusual hardship. I mean, what the hell does that mean?
Yeah.
It used to just be extreme hardship. I believe it was extreme hardship. It might have even been lower with suspension. 212C relief, that was taken away by IIRIRA. I don't think we as a country, when push comes to shove, when you know the non-citizen, maybe in the abstract, I don't think we as a country, I could be wrong, the majority wants this country to really not permit long-term people who have lived here for a long time with U.S. citizen children to leave based on, but when you take away suspension, when you take away 212C, both of those things were essentially second chances, giving immigration judge discretion to say, you know what, you've become a good person. I'm not going to judge you based on the worst thing you've ever done. The rest of your life shows that you're a good person. I'm going to give you a second chance. All of that was taken away with IIRIRA, and now we have non-LPR cancellation of removal, which can be very under the statute. It's very hard to get.
Yeah.
So I don't know if we have as a country. I know that most non-immigration attorneys don't know about that. I think that if you ask them, they would say, yeah, I mean, non-citizens can get a second chance if they deserve it. And that's not really the case anymore. And so that's what Immigrants List does.
I've had people who are like anti-immigrant call me. They say, yeah, I don't believe this stuff, but I have this one person who's different.
Right, everyone's got this one guy.
Yeah. And they knew the facts behind who's getting crushed on this waiver stuff, this cancellation stuff, and like how it actually works. Like what we see, it's like how ridiculous some of these procedures are and stuff. I think majority of the country, like from just talking to everybody I talk with, would be like, yeah, that doesn't make any sense. But
right.
And I think probably telling the story is the best thing for people to make the switch.
I used to work for an immigration judge who's since retired, who would tell me, like, before matter of ARCG, which was the case that says domestic violence can be, to paraphrase, domestic violence can be a path to asylum. Before ARCG, which was then vacated by matter of AB, but now it's back because of Attorney General Garland. Before ARCG, these predominantly women would come into court and they'd give them a 3-hour hearing and they'd be up there talking about the horrible rape and abuse and beatings that they suffered in El Salvador, Guatemala, or whatever. And, all the machismo, all the things that you put into a domestic violence case, if the country condition evidence supports it. And he'd have to look at them and he'd say, ma'am, usually ma'am, I believe you. What you're telling me is terrible. There is no precedent that permits me to grant your case, whether in the Ninth Circuit or at the BIA. Mm-hmm. And then they'd have to appeal it. I mean, the immigrant judges have to follow the law.
Yeah.
That's why it's so important that you have things where you have an attorney general and a BIA who, have a certain view of the law and that you advocate for immigration reform.
Yeah.
With that, the last case is Gonzalez-Castillo v. Garland, Ninth Circuit, just last week. This is about Interpol red notices, which have a special place in my heart based on some of the work that the Kurzban firm sometimes does. And it's about this case, Matter of Werb, which I love saying, which is a BIA case about red notices. What were you going to say?
I actually talked about this briefly in my separate podcast because, this Interpol red notice thing is the thing that gets on my last nerve that it exists the way it does. Yeah. I didn't get too much into it because I haven't read up on it for a year. It's the last case I had on it. So I'm glad you're going to talk more detail for those listeners. Because I just said, know about it, but I'm not going to tell it to you. But you have a chance to talk about it.
Here you go. Listen to last week's episode of the pod. But, it's great. It's great for two reasons. First, red notices, but just burdens in general. It's in the context, as it so often is, in the bar to asylum and withholding of removal if the non-citizen has committed a serious non-political crime. But the provision that bars asylum and withholding is that if there are serious reasons for believing that the non-citizen has committed a serious non-political crime. I mean, it's the epitome of mushy. What the hell does that mean? You don't have to have a conviction. It's just serious reasons for believing. That's what the IJ has. But non-citizens have the ultimate burden to establish eligibility for relief in immigration court. Everybody agrees on that. But it's not like you have to come in and disprove a negative. I mean, there are a million bars to everything. You don't have to come in and prove that you didn't commit genocide, right? If there's no indication that if you weren't in Rwanda or Yugoslavia during the 1990s, I mean, there's other genocidal places, I know. But anyway, so Matter of Werb says, serious reason, whatever that means, I don't know, but actually it says more than Werb is better than that, but whatever it means, I don't know. But all DHS has to show is that the evidence indicates that it applies, and then burden shifts to the non-citizen to disprove that. Evidence indicates. I mean that means nothing. That means anything. That means somebody said it on the street corner because hearsay is admissible in immigration court. I mean, the evidence indicates. And I have been fighting this evidence indicates standard in a variety of courts for a bit now because that's not what other BIA decisions say. And it doesn't make sense under the statute. It doesn't make sense as an understanding of law. I mean, that's crazy. And Gonzalez-Castillo says two things. First of all, it says three things. It says the serious reasons to believe standard under the INA equates to probable cause. That's what that means. So the bar applies if there's probable cause to believe that the non-citizen has committed a serious non-political crime. What does a serious non-political crime mean? That's a whole nother thing. This case isn't about it. Mm-hmm. But you have to have probable cause. All right, I can deal with that. That's Ninth Circuit precedent. That's also precedent in other circuits. Then the Ninth Circuit says Interpol red notices don't equate to probable cause. That's DOJ itself. There's DOJ policy that says Interpol red notices are not probable cause. I mean, that's the most uncontroversial thing in the world. It shouldn't even be an issue. DOJ says it as official policy, but of course, that's not what happens in immigration court. The Ninth Circuit is saying that quite clearly. Interpol red notice by itself cannot satisfy the serious reason to believe serious non-political crime, because that equates to probable cause, and a red notice is not probable cause. Makes sense, right?
Mm-hmm.
Eighth Circuit said a similar thing. I believe, no, Eighth Circuit said what I'm about to say as well. Other circuits have said that too, but DOJ says it. Immigration judges and BIA are part of DOJ, but DOJ says that too. But then the most important thing, right? Because of course the BIA knows this. That's probably why they issue matter of verb. Ninth Circuit says that whole burden thing, that's not a thing. The evidence indicates you don't shift it. There's no shifting to the non-citizen, because we don't care what the regs say. We don't care what matter of verb says. The statute doesn't talk about a burden shift. Doesn't talk about any of this. It just talks about serious reasons for believing. So an immigration judge can never sustain a serious reason for believing serious non-political crime allegation based simply on a red notice. No, burdens be damned, because the record will never establish it, because there will never be probable cause based on a red notice alone. That's what Gonzalez-Castillo says. It's a big deal, I think, for all this. And, it's more nuanced. This isn't legal advice. A lot is said in Castillo. So give it a read. Also, big props to the University of California, Berkeley School of law students as well, for this big win, for this great case law on the 9th. It's a big deal. Love cases like this.
Yeah. This red notice thing is such an abused kind of thing. It's that I'm so glad that it's getting more attention. And just at a practice angle, there are a couple of immigration attorneys that have a whole practice just dealing with red notices. They've gotten known for it. So, if you get the hang of it, how to contact Interpol, try to fix it, take it off, or deal with it, all that kind of stuff. That's a whole niche that you can get into if you want to expand your practice.
It is. We often use, God, it's very hot. I'm sorry, in Southern California, my brain's working at half speed. We used, oh my God, we use a big firm in Miami often when there are red notice issues, and I want to give them their props. We use Greenberg Traurig in Miami. They've got a whole practice area for red notices. That's who we often use. There are other individuals as well, but Daniel Palacio, I believe is his name, at Greenberg. He knows how to deal with Interpol. And so much of this is discretionary, burdens, all of this is great. But if you're going into court with a red notice, you're already at a disadvantage. So it's always, and thinking to take it a step further, these are usually asylum cases. If Interpol, so I argue so often, if Interpol is refusing to recognize a country's request, to return this non-citizen for prosecution, because Interpol is saying we don't trust the request from this country. And that's what happens often when you get Interpol to withdraw the red notice. If Interpol says that, to me, that's strong indication that this individual is going to be persecuted in their home country, because look, even Interpol don't trust this country.
Yeah.
I think it's a legit argument. So shoot me an email, hit up Greenberg in Miami and Daniel, and they often do great work from these countries that abuse the Interpol process. Even matter of verb says that, in a footnote, of course, that, we don't trust red notices that are from certain countries. They don't say what those countries are. You have to show that they're unreliable. Even matter of verb recognizes that.
Well, very cool. Thanks for coming on again. Check out the Immigration Review podcast, wherever podcasts are found. Kevin A. Gregg at Gregg with 2 G's at the end of it, kktp.com. Check out the magazine, Immigration Lawyers Toolbox magazine. Learn about the conference, RSVP. We're going to have a bash. You're going to become a better attorney. You'll make more money, expand your business, and importantly, expand your network and your relationships. That's all life's about. It's really about relationships. So you can do that at the Immigration Lawyers Toolbox Winter Conference in Los Angeles. If you're cold and it's snowing in Chicago, in East Coast, you come out here. It might just be a little cloudy, but it's going to be much better. We got a lot of people from Florida who are RSVP'd, interestingly, because they probably have good weather during the winter, I'm guessing. They have hurricanes. So in February, how's the weather in Florida? It's probably
great.
Okay.
Best time. I'm surprised anybody's coming.
But even better in LA. So see you there. My goal, what I'm going to be doing is, I was going to make a general track of like visa categories and just do like 6 in one session in one conference. But I'm like, that's too much. People aren't going to learn. I want to focus, hyper focus, have like a lot of information on one topic. So you go back to your office and bring a new practice area there. And then once I learn how to do a conference, move it around and have, Las Vegas, Colorado, Miami, New York, just keep have a couple conferences going around at the same time. We focus on L's, E's, O's, all this kind of stuff. So have a circuit that we go around, small workshop group, 10, 20 people max. So we can actually talk and ask questions. It won't be like a million people in the room. So I think it's going to be a really cool experience.
Happy to promote you on immigration review when the time comes.
Yeah, once we get the full agenda down and I can answer all the questions, I'm coming on, and a lot of your listeners do other areas.
Right.
So if they come on board the employment side and learn about it. So
that's right. We're doing a special episode before 2022 is over, so that we'll align it with that.
Awesome. Well, appreciate it. Thank you, Kevin. Have a good one.
Pleasure as always. Bye.
Bye.